Hello and welcome to episode 3 of my Employment Law Snapshots. In this episode I'll be looking at a case involving a professional football club's attempt to avoid paying a huge amount of notice pay and nudity. This week, the law's really been getting in the way of a significant amount of great sport on the goggle box. Firstly, there was Andy Charisma Murray's sad defeat at the hands of Federer in the Wimbledon semi-final, closely followed by a fabulous few days of Aussie bashing in the cricket, and rounded off with Chris Froome dominating in the Tour de France. That said, I was devastated to hear that England lost to Germany in the World Marble Championships. Anyway, my sporting references are a rather clumsy attempt to find a tenuous link to this week's case, which involved a professional football club and its attempts to avoid paying one of its senior managers a significant notice payment. If you want to find out whether the club succeeded, keep watching. This week's case is called Williams against Leeds United Football Club. Mr. Williams was the technical director of the football club for 7 years until his summary dismissal for gross misconduct in 2013. He earned £200,000 a year and he had the benefit of a 12-month notice period. In 2013, the football club started a restructuring programme, and on the 23rd of July 2013, Mr. Williams was given notice of redundancy. On the next day, the football club wrote to Mr. Williams and accused him of gross misconduct. The key allegation was that he'd forwarded an email containing pornographic images to a friend at another football club in 2008, 5 years earlier. On the 30th of July, he was summarily dismissed without notice or pay in lieu of notice. Mr. Williams sued the football club for breach of contract for his 12 months notice pay and a statutory redundancy payment. So far so clear, but in this case a few interesting things came to light in the course of the proceedings in the High Court. Firstly, after the football club had filed its defence in the High Court, it discovered that on the same day that Mr. Williams had forwarded the lewd email back in 2008, he'd also sent it to a junior female employee at the club and to another friend at a different football club. So the club amended its defence to include this new piece of information. In addition, the High Court found as a matter of fact that on the 18th of July 2013, that's 5 days before Mr. Williams was served with his redundancy notice, the senior managers at the football club had already decided to try to find a way to avoid paying him his 12 months notice pay. In order to do this, the club decided to try to find some evidence that he committed an act of gross misconduct during his time with the club. This included hiring a forensic computer expert to check his computer. The computer expert discovered the inappropriate email on the day after Mr. Williams was given notice of redundancy. Mr. Williams tried to argue that because of the way the club had tried to avoid paying him his notice and the amount of time that had passed since sending the email and his dismissal, he should still be entitled to his notice pay. Mr. Williams lost. Firstly, the High Court didn't accept Mr. Williams's argument that because he'd worked for the football club for over 5 years after sending the lewd email, it couldn't amount to a breach of contract. The High Court said that the real issue was whether his conduct was sufficiently serious to amount to a serious breach of contract at the point when the football club actually found out about it. Interestingly, the High Court said that if the club had known about the email when Mr. Williams was served with his redundancy notice, any potential breach of contract would have been affirmed or waived by the football club, so it would have had to have paid him the notice pay. Finally, the High Court decided that the fact that the football club had actively decided to go on a fishing exercise to try and find something to avoid paying him, and the fact that it had already decided not to pay him before they knew about the email, and all of this occurred before Mr. Williams was given notice of redundancy, it still didn't prevent the club from using Mr. Williams's serious breach of contract to summarily dismiss him when the email was discovered. Ultimately, the High Court concluded that his actions did amount to a serious breach of the implied term of trust and confidence, which entitled the football club to summarily dismiss him. In coming to their conclusion, the High Court took into account the fact that Mr. Williams was a very senior manager, the images were capable of causing offence, sending them to a female employee might have resulted in a sexual harassment claim, and the football club's reputation could have been seriously damaged. Therefore, the club was entitled not to pay Mr. Williams any notice pay whatsoever. So the moral of the story is that employees will still remain vulnerable to historic acts of misconduct that are discovered late in the day by their employer, even after they've been given notice for an unrelated reason. That said, it's still slightly surprising that the High Court were as sympathetic as they were to the club, given their motivation to find a reason to avoid paying Mr. Williams a significant sum of money. As such, fishing expeditions are still quite a risky exercise to pursue, and it's certainly worthwhile getting some proper advice before doing it, particularly when a lot of money's at stake. And finally, this week you'll probably have missed the fact that America celebrated National Nude Day. Some employers decided to embrace this important event at work, and the best example involved a television station called Fox 17, which managed to embarrass its presenters live on air when their floor director suddenly appeared in the buff in front of them. Thankfully, he was facing the presenters, so the television viewers only got the benefit of the dodgy tan lines on his back. The same can't be said of the presenters. Have a look on YouTube if you want to see their reactions. They're pretty good. Obviously, I've decided to celebrate this auspicious day with our American cousins, so if you just want to pan down, only kidding, see you next time. Thanks for watching. I hope you enjoyed our third episode. If you want to subscribe to our YouTube channel for more updates, click here. If you want to follow us on our Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you just want any more information or help, please go to our website by clicking here. Also, all of the links are below. Once again, thanks for watching and see you next time.